Good day, everyone. I am Stacia May Vergara, and I'll be discussing the chapter 2 and 3 of the Labor Code, which talk about the powers and duties of the labor arbiters and the National Labor Relation Commissions, or the NLRC. But let us first tackle the jurisdiction under Article 217. So basically, the labor arbiters are like the first level judges for labor cases. They handle unfair labor practices, termination disputes, wage issues, damages, and even cases about the legality of strikes or lockouts. But take note that they only handle money claims above 5,000. And anything smaller usually goes to the dollar regional offices. And when the labor arbiter makes a decision, and if someone disagrees with the decision of the labor arbiter, then the case goes up to the NLRC, which acts as the appellate body. Next is the powers of the commission. So what can the NLRC do? They have broad powers actually. They can make rules, summon witnesses, and even hold people in contempt if they misbehave. They can also issue injunctions or restraining orders to stop illegal acts in labor disputes, but only under very strict conditions. So they are not just decision makers, they are also enforcers. Next is the ocular inspection. So here's something interesting. Both the arbiter and the commission can actually conduct ocular inspections. So this means that they can visit a workplace, inspect machines, and even talk to employees directly to gather facts. So it's not just a paper-based hearings. They can actually check the actual situation or the situation inside a workplace. Next is the technical rules. So unlike regular courts, technical rules of evidence are not strictly followed here. The main goal is speed and fairness as well as facts. So also before anything else, the arbiter must first try to encourage both parties to settle amicably, or in short, in a friendly and peaceable manner or peaceable way. That shows that the system prefers peace over conflict. And next is the appearances and fees. Here's a quick note. Even non-lawyers can appear in hearings as long as they represent themselves or their organization. And for union members, good news, you can't be charged attorney's fees individually for CBA negotiations. Only the union funds may be charged. And now, let's move on to the chapter 3 of the National Labor Relations Commission, which is the appeal. So first, under Article 2 to 3, the decisions of the arbiter are final unless appealed within 10 business days. I mean, within 10 days. But you can't just appeal for no reason. The grounds are limited, abuse of discretion, fraud, legal error, or serious factual mistakes. And one key thing, if an employee was ordered reinstated, and that reinstatement is immediately executory, meaning the employee goes back to work or at least back on payroll even while the appeal is pending. Next is the execution. So once a decision is final, it must be executed within 5 years through a rate of execution. Sheriffs or officers carry this out, and there are penalties for employers who don't comply. And last article is contempt powers. So lastly, the Secretary of Labor also has contempt powers. This means anyone disrespecting or obstructing the labor process may be fined or even jailed. So to wrap up, the labor arbiters handle the labor disputes at the first level. The NLRC reviews the appeals and enforces decisions, and the whole system is designed to be faster and less technical than regular courts, while still protecting the rights of both workers and employers. And that's the essence of Chapter 2 and 3 of the Labor Code. Thank you, and I hope this gave you a clear picture of how labor disputes are resolved in the Philippines. Thank you.